I'm going to get started in just a second, but welcome as you guys join. Okay, I'll go ahead and get started. I'm Greg Siskind. Welcome back to those of you who've been here before. I am an immigration lawyer with Siskind Susser. I also litigate with Impact Litigation, which is a joint venture of three law firms that we sue the government on high impact immigration cases. And I'm here today to talk to you about what's happening in immigration news, as well as answering your questions. Chuck Cook and I, one of my fellow litigators in Impact, we do our YouTube program on our cases on Tuesdays. 2 hours ago, we did it at 11 Central Time, 12 Eastern. So I'm not going to spend a lot of time talking about litigation because I would just suggest you watch the recording summarizing where we are in our cases. That's on our YouTube channel for Impact Litigation. That's IMMPACT litigation.com. But I'll talk a little bit about it, mainly because I'm trying to educate people on this new case that we're getting ready to onboard. We want to file this thing quickly as a class action. We need to have a minimum number of plaintiffs on that to be able to file it, and we shouldn't be that difficult to get it, but we want to file this thing as soon as possible, and we just need to get to that number. We're not charging anybody to be in this case because we're going to be collecting damages from the government and charging on a contingency fee, so we'll get paid out of the government whatever we collect from the government. If we don't collect anything from the government, then we'll eat the fees, but our plaintiffs will not have to. So I'll get to that in a second. I did want to tell people about just some immigration news. I'll talk also about legislation because I know a lot of people you want to know about the Build Back Better stuff that I can tell them, and I'm happy to talk about that. As far as immigration news for the week, there's not a lot that happens in a holiday week, but one thing that was of note is that the Biden administration has announced that the USCIS has announced, not the Biden. Well, I mean they are part of it, but USCIS has announced that they are now moving on yet another process, TPS processing in 765s, into electronic filing. E-filing may sound like kind of a dry topic, and you may say, well, what do I care about it unless it's for my own application? But that is part. Most of you are upset about processing times at USCIS and the State Department, and one of the ways that the government can fix a lot of these problems is to move away from paper filings, move away from everything being manually done by a human, and having more processes automated. So e-filing is a part of that. So to the extent that you can enter all of the information in your case on a form that's electronically filed instead of filed by paper, that should improve processes quite a bit. And 765s are part of that process. So we'll see if we'll see what the next e-filing initiative is. Of course, it's also, I think, going to be probably a key to whether they premium process, which processes are added for premium processing. I think the more that they can move into e-filing, the easier it's going to be for them to start allowing more processes to be premium processed, and for you to be able to pay for the kind of service that you guys want. I don't think that there was that much to report in the last week otherwise with immigration news, but I did I have heard a few things regarding what's happening on Capitol Hill as far as the Build Back Better legislation. So just a reminder of what I'm talking about with that. This is a bill that is is about a lot more than immigration. It's a massive $2 trillion plus bill that covers a lot of what they call social infrastructure or human infrastructure, and among other things, there's universal pre-kindergarten. There's paid family medical leave. There's hundreds of millions of billions of dollars that's to be spent on climate change issues. I mean, it really covers a broad array of issues, one of which is immigration. And immigration, there's two major parts to the immigration proposal in the Build Back Better bill. One is a parole program that will benefit somewhere probably between, I don't know, 4 and 8 million people, if I had to guess, that will allow individuals who are undocumented or documented who have been in the U.S. a certain amount of time to be able to get a work card and a travel document and be basically, free from worrying about removal as long as they have that status. That parole is the third attempt the Democrats have had for a proposal for dealing with undocumented folks. The first two were rejected by the Senate parliamentarian because there are a lot of strict rules for this particular kind of bill, which only requires 50 votes instead of a normal 60 votes. That has to have a certain budget impacts and be primarily a budget proposal. The parliamentarians said, the DREAM Act or the moving of the registry dates were not just about budget issues. The good news is that there are some signals that are emerging indicating that the parliamentarian may be treating this proposal more as a budget issue. She's asking questions apparently of the Democrats about finance, about the how what the financial impact is of these proposals. A lot of people are reading that as an indication that she might be okay with this proposal if the numbers work. The other part of the proposal is backlog reduction changes. So, and among other things, it recaptures about 500,000 green cards, probably about half family, half employment, for people that, for unused green cards over the last 30 years. There is a provision that allows for the diversity visa unused numbers from 2017 onward to be basically for each lottery to be reopened so that the numbers can get finally used for those years. There is a proposal that there's a section of it that would allow people to file an adjustment of status application even when a visa number is not immediately available. There's a proposal to allow people to pay a supplemental fee and avoid the country caps, so that that's obviously welcome news for a lot of people. And then there's just a tax on visas that's in the proposal as well, which hopefully will help with the parliamentarian part of it by showing it is a tax. It's tax legislation, not just immigration legislation. So that being said, we don't know. We haven't heard any comments yet from the parliamentarian on that part of it. I did hear from a source this past week that said that they somebody had already gotten signals that that language was okay, and it was just a parole language that they were worried about. I don't have any confirmation beyond, basically secondhand information on that, so I can't say for sure. But I am starting to feel a little bit better about the prospects for that bill. Obviously, it's not just the parliamentarian issue. It also, even if the immigration provisions get to stay in there that the House already passed, the overall bill still has to pass the Senate, and I don't think we're there yet. I think we're at 49 votes. There's a 50th vote that's needed from Senator Manchin of West Virginia, who has yet to, signal that he is comfortable with the bill language. So I don't think there's that much more I can add to it. I'll look in the questions to see what you guys have to say on that. I did want to get back and talk a little bit more about this fee case. So, what we're suing we're suing both the Department of State and Immigration and Customs Enforcement. The Department of State we're suing for something that's in the news again today. And if you look at my Twitter feed just today, you will have seen it. So these various visa bans that have been the travel bans that have been implemented since the beginning of the Trump administration, the Muslim ban, the non-immigrant visa ban, the immigrant ban, the COVID travel bans, they all stem from this section of a law called Section 212F of the Immigration Nationality Act, which says a president can bar the entry of an individual or group of individuals that is deemed to be basically in the national interest. And it's the statute is very specific as far as limiting it to its applicability to entries of individuals. The State Department has taken the position that that also implies that they have the ability to ban the issuance of visas, saying that if you can't enter the United States, then why would we issue a visa? The problem with that is there are a lot of reasons why you would still want to issue visas. First of all, like for example, on the COVID bans, they're only a ban on entry if you've been in a particular country for the last 14 days. So if somebody's able to get a visa and they just go to another country for 2 weeks, they can enter from there. So it's hardly a ban on a person coming to the United States. It's just a ban on the entry of a person coming directly from a particular country, that if they've been in that, and as long as they're out of that country for 14 days, then there's no issues with them entering the United States. That's one group. Another group would be, for example, diversity visa winners who had to get visas issued by September 30th. And the yes, they need to under the immigrant visa bans or they would have needed the president to lift the ban on entry in that category. However, the expectation was, especially since these bans were only for a couple months at a time, that as soon as the ban was lifted, the person could then enter on the visa. Of course, if you don't provide a visa by a certain date, then they have permanent damage. That's another group. But there were lots of examples where somebody still could benefit from getting a visa, even if they couldn't enter the U.S. immediately. And we sued on that in 7 cases, I think now, and we're successful in all of those cases, with the judge saying no, that's an illegal policy. We just saw this morning with and that's obviously the other news this past week was the travel bans that have been reimposed on African countries because of the Omicron variant. The State Department this morning, the consulate in Johannesburg actually pulled a switcheroo. They yesterday and the day before, they had been saying on their website they were going to continue to issue visas. In fact, I think I had tweeted that language out. And today they've changed their language and gone back and said, no, if you're subject to the ban, we're not issuing you a visa, which is the illegal policy. So that's that group of plaintiffs. What we have seen now is that the State Department has a never refund policy. Once you pay for a visa, if they cancel on you, they cancel on you, not you cancel on them. If they cancel the appointment on you, they don't issue a refund. If they deny your visa because of the travel ban, which we know is illegal, they don't issue a refund. If you book a new appointment, you have to pay a new fee. They don't give you a credit toward filing to the next filing fee because you had paid a fee already for a service that you never got. They keep your money and you're out of luck. That's illegal. And that's what we're suing over for one group of plaintiffs in this case. If you have ever paid money to get a visa, whether it's an immigrant visa, a non-immigrant visa, if you've paid money to the State Department for a visa and you did not get an appointment, or you had an appointment and your visa was denied for the based on a travel ban or an entry ban, and not because you didn't qualify for the visa in other respects, like you didn't meet, whatever the requirements are. We are seeking to recover the filing fees for anybody in that situation and get them their money refunded. So if that's you, you should look at the at potentially participating in that case. Um, that being said, the second group that's tied to that is for people that paid SEVIS fees. So SEVIS is the Student Exchange Visitor Information System. And if you are applying for an F1 student visa or a J1 exchange visa, you have to pay the SEVIS fee before you're even allowed to make an appointment to seek an F or a J visa. And so basically on top of on top of the visa fee that you paid, you may also have paid an extra couple $100 for the SEVIS program on top of that. And we are going to seek refunds of the SEVIS fees as well, because you should not have been charged a SEVIS fee if the government had no intention of actually issuing you a visa. Hang on a second. I'm going to post in the. I'm going to, if I can figure out how to do this. I want to post the address. Chuck always does this when we're on the other. We're on the YouTube. Let me see if I can figure this out. Creative. Here we go. Okay, that is the address for information on the suit. The other group, I think this, the other group's kind of is interesting as well, and actually covers a much broader number of people. We discovered actually Brent Renison, who's co-counseling with us on this case, discovered something very interesting that was going on at the State Department 8 years ago. The State Department, they charge this machine readable visa fee in every non-immigrant visa application that's filed. So this is millions of applicants a year. The machine readable visa fee, and I think it's $160 or $164. Anyway, that fee, there's a regulation and a statute that says what they are allowed to charge when they calculate the machine readable visa fee, and it's essentially they're supposed to charge what they're based on the cost model for what it actually costs them on average to adjudicate a non-immigrant visa, and that's what that number is supposed to be. They were audited in 2014, I believe, by the Office of Inspector General at the State Department, and the OIG hired an outside auditing firm, Kearns and Company, to conduct this audit. And what they found is that the State Department, the Consular Affairs Office of the State Department, which came up with the fee, was overcharging every person that was applying for a visa, and it was amounting to potentially hundreds of millions of dollars a year in overcharges. They explained how the calculation worked and why they came up with the number, and the State Department essentially said, "Screw you. We think the number is right. We're not changing anything." And they didn't on there, and they kept the fee the same, and they have never adjusted that amount. In fact, the OIG said you should take the overcharge and send it to the Treasury, because it's not, you're violating, I think it's the Anti-Deficiency Act, and there's, but by keeping the money. But this report was pretty scathing, and it was just basically ignored by the State Department. So we have there's a statute of limitations, and even though this was discovered that it began, I think the overcharging began in 2012, but we are suing on behalf of anybody that has applied for a visa since 2016, whether you received the visa or not. Even if you were denied the visa, for grounds that are completely legitimate, that they said you didn't qualify, you were still overcharged for the service that was provided. So we are seeking to get all the overcharging refunded to um, to everybody that applied for non-immigrant visas since 2016, and that so obviously that covers that covers a whole lot of you. And Anyway, that's that's the other part of this case. And if you are interested in participating, this address on the screen is where you can go and see the FAQ. We are doing this as a class action, so that we don't need to have everybody identified. We just need to have a sampling, and we are not charging anybody to be in the case. So it's really just a matter of your time and filling out the little form that we have to be able to join the case. Um, and then if we will get paid if we're successful, and we collect money from the government. We're filing under something called the Tucker Act, which is a statute that normally you can't sue the government for financial damages. And a lot of people ask us in these cases, why don't why don't you sue for damages for what they did to us? And normally we can't because of sovereign immunity rules. However, there is a different policy with respect to paying for a service that wasn't delivered. And we can sue under this statute called the Tucker Act in the Federal Court of Claims, and that will allow us to seek to recover the excess, to get a refund of the overcharging that I just discussed, as well as a complete refund for people that paid for a service that they never even got. In the case of the travel bans and the immigrant, non-immigrant bans, and the Muslim bans. So hopefully, hopefully, we'll get the number of plaintiffs that we need relatively soon, so that we can file that case, and we can hopefully get relief soon. And you know, I feel like there's been a fair amount of arrogance at the State Department over the years, particularly when it comes to. I mean, it's chutzpah, basically, to use a Yiddish term, for the government to not only not issue you a visa illegally, but then to not even issue you a refund of the fee that you paid for that service that they're not giving you based on their illegal interpretations. And there's it's not just about getting the money back; it's about sending the message that the State Department is not is not a power. It just does not have unlimited power. They do have to answer um, to the courts, and certainly I think they have to. You guys are customers, and you've not been treated as customers. Certainly not customers that would ever, that we would ever consider acceptable in our own lives. If as managers of businesses, if we ever provided that kind of customer service, or even just anybody that interacts with clients, that's unacceptable. So hopefully that will be something that we can file shortly. All right, so let me get to your questions, and let's see what we've got here. So I just did the update on the provisions. Do I expect the parole BBB to change? So far, I haven't heard any indications yet that the parliamentarian has issues with that language, so I'm expecting that probably for now will stay the same. Well, let's see, maybe you have got information I haven't seen. Some tweets saying the language is being modified to give more power to the DHS secretary over parole, and the duration of parole would be significant. Parole is going to be limited and hence will benefit far less people than previously thought, but will help anyone who's a U.S. citizen relative. So I haven't seen that yet. If you want to put in the comments, actually, who is tweeting that, because there are some reporters that are doing a really good job reporting this stuff, and it's possible. I've been working on a number of writing projects, so I'm not spending as much time on Twitter right now. But I would be happy to take a look and be helpful to me if you've seen some information from there are some advocates out there as well that have information, but for the most part, I usually rely on. There's a handful of journalists that I would consider reliable, some handful of staffers that are not on Twitter that I get information from, and then there are some advocates in some of the immigration organizations also that provide me some helpful information. Uh, Good evening from South Africa. Any indications that the travel ban will be lifted? Well, unfortunately, the both the Biden administration and Trump administration were quick to impose travel bans in the past and very slow to lift the bans. I was happy to see a lot of criticism of the Biden administration, particularly over including South Africa in the ban, because South Africa basically did the world a favor by finding out about this and alerting the world to it, early on when there was a chance to do something about it. And imposing a travel ban is basically only going to, I mean, first of all, it seems like a punishment for South Africa as opposed to being truly about health policy. And the other thing is, I think it's going to have the effect of in the future countries not providing, keeping their information close to the vest because they don't want their citizens to be punished essentially for that. So I am guessing that in a few weeks' time, we'll look at the numbers, and if it looks like in the past, what happens is there's a wave in a country, and they are added to a travel ban list, and then the numbers go back to normal, and basically, oftentimes even lower than other countries. And they're not taken off the list. China is the perfect example of that. China was put on the travel ban list right at the beginning of the COVID, and they got their numbers down to essentially zero um, in the country. And the China travel ban wasn't even lifted until November 8th of this year, even though they hadn't had hardly any cases in the last year. So that's been the past. We'll see if the Biden administration is planning on making any changes. But and whether all this criticism, I know the president had to answer a question on that yesterday, so that's always good if when he has to answer that in public. So I don't know when it's going to be lifted. If the pass is an indication, it's not going to be soon. Keep in mind the travel ban is a ban for 14 days on traveling to the United States. So if you go to another country for 14 days, it won't apply to you. In the past bans, we've had people basically go to Mexico for 2 weeks and then cross in from there, or go to other countries that are not on the list. But for right now, there's a handful of national interest exemption categories that have been vaguely listed as and some other categories like permanent residents and citizens. So um, there may be some announcements in the next few days regarding exemptions from the travel ban, like there have been for the ones in the past, and we'll see if those are, if we see anything like that coming. Okay. And here's another person who is noting this changes in parole. Yeah, tell me in the comments where this is, who's reporting that. As a, I could see that, what the reason might be to do more limiting like that. If the parliamentarian is saying, for example, that the program is too broad, but I haven't seen that yet. So, not saying it's not true. I just don't have any confirmation to give you on that. Will the final action date for EB2 India move over the next few months? Where is it expected to be by the end of the fiscal year? So interestingly, actually, I'm going to pull this up. The AILA gets a report from the State Department monthly from Charlie Oppenheim, who I guess gave his last check-in because he's leaving the agency. I don't know who's going to be taking over, but they did provide some useful information, and so I'm just going to read a couple of the things that were on here a week. So one of the things they said was that this is with regard to employment base. USCIS had been processing 7,000 to 8,000 adjustment applications per week in August and September, and that was affecting the movement. They said that that was going to be hard to expect that pace to continue. But if USCIS were to process 5 to 6,000 a week, when combined with there's apparently more numbers that are being issued at consulates overseas. We'll see if that continues. That they thought that they could exhaust the 280,000 green cards before the end of the fiscal year, which would be good. That's what we want them to do. We wanted them to use up all the numbers. We don't want them to waste numbers like they did last year, 80,000. So there's some optimism expressed that they are adjudicating at a fast enough pace that they won't have the same problem for this year. So that's good news. With respect to EB2 India, this is what they said. They said that state advanced the EB2 India number 6 months from December 1st, 2011 to May 1st, 2012, and that was more than they thought that they were going to be able to move it, but that and they still don't know how many upgrades are going to be coming from EB3 to EB2, and so they're kind of wanting to test out the water and see, this month, see in the next month, which I guess starts tomorrow, how many upgrade applications that they get as a result of the upgrade. So they are, they've said that they essentially are stepping on the gas early to test the demand, and then they would likely pull back on advancement with the possibility of advancing again later in the fiscal year. So what this means is that if you benefited from the advancement, do not assume that it's going to, that they're going to continue the advancement for what it sounds like they're going to do is if they get a lot of applications and they get a lot of upgrade requests, then they will probably retrogress the numbers again or just keep them where they are, and then kind of wait a few more months till, my guess is March, April, May, and then advance the numbers again and kind of take their, and count the demand. So that's I think that they're waiting to see what kind of reaction that they get in terms of applications to this advancement. Let's see what else that they had in here. So the original plan was to be aggressive in the first 3 or 4 months of the fiscal year, scale back while monitoring the impact of the movement, of the aggressive movement, and then maybe advance again. So it's possible that they may not have enough information to be able to move aggressively later in the year, and for that reason, they're going to movement. The movement in January, they said, may indicate what they're expecting for the next couple of months. So as far as Charlie Oppenheim goes, by the way, he is supposedly working. They don't know who the replacement person is yet, who's going to be authoring the bulletin. He's supposed to be helping during a transition, and we'll see. I think he's going to be missed. I think people trusted him and think that he's probably made some decisions over the years to be, use his authority to be able to help as many people as possible. I'm not so sure that that would be the case necessarily with others. With regard to EB3, so what he did say, by the way, on that was that so the rate of EB3 overseas processing has been surprising. They have that the Department of State's already processing a lot of rest of world EB3s, and they've been increasing processing at Manila, Mumbai, Guangzhou, to address backlogs. So if it increases at a higher, if it continues to go at the higher rate that it's been at, that they believe that it might deplete numbers available for the worldwide annual limit, which is something that I think people would be unhappy about. So that sounds like that might be coming if you are EB3 worldwide. So keep an eye out for that. Anyway, that's what I can tell you with respect to movement of the visa bulletin over the next couple of months. Melanie's asking, they have a biometrics appointment on Monday for the K1 adjustment. No work permit yet. Hopefully after biometrics means interviews soon. So yeah, I mean, but that's it. You have to get that out of the way. I think we still are seeing across the board problems with adjustment. I mean, EADs, regardless of the category. There's not one that's moving along at a super fast pace, but biometrics are at least an indicator that I mean, it has to be out of the way. I'm not sure that it's going to be immediately that you're going to hear something right after that, but hopefully that will be the case. Updates for F2A category about interviews in embassies. So I'm just looking at F2As on this bulletin as well that I got. Family preference categories experienced respectable use through October 2021 to where they are hoping the F2A final action date remains current, and the date for filing date for all F2As advanced from June 1st to September 1st, is suggesting a final action date may be necessary in the next couple of months. So for right now, at least the visa bulletin part of it looks okay. And with respect to interviews at embassies, it's really depends a lot on the embassy. They are not supposed to be prioritizing anymore. That was, supposedly that policy was declared illegal. We are hearing reports that consulates are still doing that. But I think it very much depends on the particular consulate. But, it seems like F2As, the overwhelming majority of which are done at consulates and not in the United States, that those numbers apparently are getting used according to the State Department visa bulletin. So people are getting their appointments. So that's really all I can tell you to answer that question. Do we have any update on H4 in EAD class action litigation? So that is I forget the name of the case. Ayla is litigating a second H4 case. There was the first one, the Shergill case, which they settled. That was the one that had that very unsatisfactory settlement regarding allowing for automatic employment authorization document extensions for H4s, but only through the end date on the I-94, which didn't help a lot of people because the EADs and the I-94s tend to end at the same time. So the second Ayla suit is designed to push this further, and that suit has not. I don't have any news to report on that. There hasn't been a settlement or anything like that. The Kane case, which I'm co-counsel on, which we talked about earlier, that is dealing with adjustment EADs and with E2 EADs. And then there's another case out there that's dealing with asylum EAD. So it seems like there's a lot of litigation pressure on the agencies, and hopefully they will get there. Something, we're going to ask for things like premium processing for EADs to at least have a date announcement of when they're going to release a regulation. We want to have a maximum 180-day commitment from the agency. We want to have the ability to file earlier. We would like to have H4s and H1Bs decided simultaneously. I mean, there's a lot of things that we would like to see overall in these cases, hopefully in terms of settlement negotiations. But we're just going to have to see. Would I recommend sending a new I-45 and EB2 if not current and final but eligible as per filing date? I already have an EB3 45. So that's an interesting question. So the EB2 file, yeah, I mean, you have the option of filing a second adjustment application based on a second I-140. If you have an EB3 filed, if you don't have two I-140s and you did a downgrade and have an EB3 45, then you can notify, but I don't think that the filing date chart is going to do it. I think it's going to have to be the final action date chart as far as interfiling or getting them. And I don't think you need to notify you can file a new adjustment application if you want. Um, if you have a second I-140, if you have a same I-1, if it's basically the same I-140, and you filed an amendment to be able to file the adjustment, then I think you're going to have a problem. If you did a second I-140 for that EB3 adjustment application, then I think you can do a new adjustment application. If you don't want to pay the fees for a new adjustment application, I think you're going to have to wait till the final action date chart is available. Hope that answered your question. How much is the waiting time in getting a final decision of a J1 waiver from USCIS? So there are different kinds of J1 waivers. I'm just going to look up and see if I can find out for you what they are reporting. But the J1 waivers, there are no objection letter waivers, hardship waivers, persecution waivers, and waivers based on interest of government agencies. So I'm looking up real fast for you what they are reporting for the, it's an I-612, and it should be, I think it's California Service Center does all of them, but they are saying, hold on, I'm looking at their table, that they are processing hardship waivers from June 3rd, 2021. 4 to 6 months is what they're reporting for hardship waivers from USCIS. Now, keep in mind, the State Department on a hardship waiver has to make its own decision, and they can take a couple of months for that. J1 waivers in general, though, don't seem like they're taking longer than historically has been the case. So that's a, that's what I can tell you on that one. Let me see if I can find out if the Vermont Service Center, what they have to say regarding I-612s, which is the waiver application. They are reporting they are taking 2 weeks to 6 months. So it sounds like it's sort of a broader range, but the end of the range is about the same. That should include the other kinds of waiver applications, including no objection letter. So that's hopefully, it sounds like 6 months is the outer limit for what USCIS is taking for the 612 part of the case. All right, so listen to the recording and rewind if you didn't hear what I was talking about before regarding projected movement in EB2 that State Department was reporting. Let's see. Is it possible to challenge the South African consulate for not issuing visas because of the ban? Since, yeah, I mean, that's a question. Is I think there could be litigation on this. The only problem is that it's going to take, if a suit was filed, then it's going to take at least a couple of months to be able to get to the point where a judge, where the government hits its deadlines for responding, and then a judge has to issue a preliminary injunction, which is very possible. I mean, I would say that if there, are a group of South Africans that want to get together to fund litigation on that, I think it would probably be possible to do it. The only thing is that I don't know if we have a good indicator yet about how long this is going to take. So yeah, the answer is possible. To do that, and a court would have to, it's going to have to make a decision. Fortunately, there's a lot of good case law, though, on this issue because of these previous cases. What does recapturing unused DVs mean? Running additional draws. So, yeah, so that's interesting. There's not a lot of information in the Build Back Better Act about what it would look like, but basically, if I had to guess, what I would say probably would be the case is technically the DV 2017, 2018, 2019, 2020, 2021, there would be an announcement saying that the deadline for the deadline for processing is being each lottery is being reopened, and they will adjudicate until they're finished with each allotment on there. And probably they would have to, the problem is that there may be more people applying than they have visa numbers left. My guess is they would probably favor people that had already filed applications. So if you can, if you can document that you started the process at filing the DS form, and you just didn't get done in time, or you were subject to a ban. I think it's only limited to people who are subject to bans. So it's probably 2018 are only going to be people that were from Muslim ban countries. And then after that, it's going to be the immigrant visa ban and the COVID bans are going to be and I think also anybody who didn't get visas, not just for the bans, but because consulates were just not operating. For those cases, I think it would be probably you're just going to have to show that you were pursuing it and then you didn't get, then the process wasn't done they shut it down because it wasn't done in a timely manner. We don't know. I don't have a lot of details on it because of legislative line. I mean, literally, it's like 2 lines in a bill. Uh, so the State Department and USCIS are going to have to essentially work out a policy, and that's why they're giving them 6 months to figure it out once the bill passes. Um, Lawsuit seeks, yes, we are seeking a refund of the machine readable all of those fees for anybody that had their money taken from them by the State Department that they paid for a visa application and then they had their appointment canceled and were not issued a refund, or they were denied, saying that they were subject to a 212F ban. All right, Shroud. The U.S. Department canceled tiered approach when placed by giving all authority to embassies to select which categories. Is that illegal with no regulations? The answer on that is probably not. They are probably, they should be, if they appear to be favoring. I mean, there was actually a case that just came out yesterday that out of New York that seemed to indicate that they do have more discretion in that regard. But generally speaking, they are not supposed to disfavor any particular categories that unless Congress okay that. And that was why Judge Maida in Gomez and in Go said that the policy was illegal, that they couldn't disfavor diversity visa people. But that seems to be largely being ignored by the State Department. So my guess is that we'll continue litigating on that. Will there be any in the January? So I already addressed that. They're still basically they're looking and seeing what kind of demand there is, how many applications come in the next couple of weeks. And so what I'm guessing is that the January visa bulletin is going to come out late in December. So don't have a freak out if you don't get if they're, it's being delayed. They are probably wanting to get as much data as possible on how many people are applying during the month of December before they decide what the January numbers are going to be for EB2 on that. So that's my prediction. Anyhow, that is there's some more questions. All right, so I'll keep going. Do I think that Vikas, how are you doing? There's going to be any positive movement for EB3 India in the fiscal year? Hard to say at this point. It sounds like EB3 worldwide numbers are being used in bigger numbers than were being anticipated, which means there's not going to be as many numbers rolling over from worldwide to leftovers into India. But there should still be a lot of unused family numbers that are still benefiting largely India. So that's I'm guessing if there's movement, it's going to be relatively modest, but there might be some. I think I had told people last year, my prediction was with all the downgrading that was happening, that probably what was going to happen was EB3 was going to start to move backwards and EB2 was going to start to move forwards as there was sort of this rebalancing of where people were applying, and that they would and the hope was that they were just going to use all the numbers, so actually EB2 and EB3 would advance, and obviously we didn't see that. But if I had to guess, I would say EB3 may advance slightly, or it may even retrogress as the EB2 numbers continue to move forward. And I think that's because a lot of the people that are in both categories, and they're just pursuing adjustment in whichever category moves faster. EB5. EB5, this is interesting. So December 3rd is the date to look for. That is the date that the federal government is funded through. And the Conrad 30J1 program for doctors, the Special Immigrant Religious Worker program, and the E-Verify programs all expire on December 3rd. And in the past, EB5 was extended along with those programs, which tend to get extended in, normally in 2 to 4 year increments, except when the government's being extended for 3 months at a time. Um, but there's some hope that EB5 will be moved back in there. Some of the people that are in the EB5 industry are now saying that they don't think it's going to be till March or April that we see any movement on that. Um, I just don't, I'm not as involved with advocacy on EB5 to have, inside scoop as far as what's happening legislatively. There's nothing in the Build Back Better program that does anything for that, for the pilot program. Of course, the regular program never expires. So, for people that are looking to do EB5, that's still a possibility. But for the pilot program, for the regional centers, if it doesn't happen on December 3rd, then I think they're right. Probably it's not going to be till next spring. So that's what I can tell you on that. Would the budget provision and Build Back Better lead to backlog reduction in processing applications to the regular times, or is that gone forever? No, it's still in the bill. We still don't know. I talked about it earlier. I do think the backlog reduction, the recapture language would probably get rid of about 75% of the 75% probably of the backlog for at least for India and China. And on the family numbers, it would probably do fairly similar reductions in backlogs there. And then the rest, and then we'd see further backlog reduction because of the ability to pay the extra fee. So that's all I can tell you. No, I don't think we've seen a real detailed analysis yet coming from any of the think tanks on how, what the bill would mean for actual categories and how many would, what would happen if it passed. So we'll just have to wait and see on that. But my guess is that we're looking at probably about 250,000 employment numbers that are taken out of the queue if we got the recapture language in there. So remains to be seen. And this will be my last question. What are the chances? When can we expect it to pass from the Senate? So I would expect probably we'll know maybe next week what the parliamentarian has to say about the immigration language. And then they are scheduled to have a vote no later than December 25th on the whole, in the Senate on the whole package on there. So December is, it's not going to drag on for months. It looks like they are wanting to get this done as the last thing that they do before they leave on their Christmas vacation. And that will be an incentive to get it done because I'm pretty sure that they don't want to stick around. And that's happened before. And there are a lot of unhappy people in Congress when they don't get to go home. But that's what they're anticipating as a December 25th final passage. So we will have to see. In any case, I want to thank you guys for coming around again, and I will should see you. Well, actually, next week I will not be here. I'll see if I can get a substitute, but I am speaking. God, I got a bunch of talks. I'm speaking on Friday in Santa Fe, New Mexico, to the American Immigration Lawyers Association Latin American Chapter Conference, and then on Sunday night I'm speaking to the IMG Task Force, which is the physician immigration lawyers. And then on Tuesday, I'm doing a webinar at lunchtime on the entrepreneur parole program to immigration lawyers. And then on Wednesday, I'm speaking on technology in a technology program, the American Immigration Lawyers Association. So I am going to be tired after all those talks, but that will mean that I will not be here on Tuesday of next week. I might be able to be on the YouTube video beforehand because my program is at lunch, and then I have to catch a plane. So I will I will talk to you all hopefully next week on YouTube about the litigation, and then I'll see you on Facebook probably in 2 weeks. Wish you all well, and I'll talk to you again soon. Bye-bye.